Hello learners, I welcome you all to your educational channel Learn and Educate. Let us continue with our law series. In the previous few lectures, videos, we have learned about part 2 execution, procedure in execution. Under that heading, section 51, 52, 53 and 54 it will taught. Procedure in execution includes section 51 power of court to enforce execution. Section 52 enforcement of a decree against a legal representative. Section 53 liable of the ancestral property. Section 54 partition of estate or separation of shares. And under the heading arrest and detention, section 55 arrest and detention. Section 56 which deals with the prohibition of arrest or detention of woman in execution of a decree for money. When notwithstanding anything in this part, the court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for the payment of money, which means that prohibition section 56 is named as prohibition of arrest or detention of a woman in execution of a decree for money. In this, nothing in this part, nothing anything contained in this part, notwithstanding anything in this part, the court shall not order the arrest or detention in the civil prison of a woman in execution of a decree for the payment of money. The decree which will be executed only for the payment of money. The order is payment of money. Then for that purpose, a woman will not be detained, will not be arrested, and in the civil prison just because for the execution of decree which is in the nature of payment of money. Section 55 substantive allowance. Section 55 the state government may fix scales graduated according to rank, race and nationality of monthly allowance payable for the subsistence of judgment debtors. The state government may fix according to the graduated according to the ranks, race, nationality for monthly allowance payable for the subsistence of the judgment debtor. Section 58 detention and release. Every person detained in the prison in execution of the decree shall be so detained: a where the decree is for the payment of a sum of money, where the decree is for the payment of sum of money exceeding 5,000 rupees, where the decree is in the payment of money exceeding 5,000 rupees for a period not exceeding 3 months, and where the decree is for the payment of a sum of money exceeding 2,000 rupees but not exceeding 5,000 rupees, then for a period of not exceeding 6 weeks. The detention and release, the period of detention, the period of putting that person in the civil prison for the purpose of execution is where the decree is for the payment of a sum of 5,000 rupees. Then the detention will be for a period up to 3,000, up to 3 months and not more than 3 months. When the decree is for the payment of a sum exceeding 5,000 rupees, for example 6,000, 7,000, more than 5,000, 5,100, 5,500 or 5,300, then such detention shall not be more than 3 months. And where the decree is for the payment of a sum of money not exceeding 2,000 rupees but not exceeding 5,000 rupees, that is above 2,000 but below 5,000, when the amount is 3,000, 2,500, 4,000, 4,800, 3,100, which is not exceeding 5,000, then such period of detention will not be more than 6 weeks. Section 58 subsection 1a the removal of doubts. For the purpose of removal of doubts, it is declared that no court, no order for detention of the judgment debtor in a civil prison in execution of a decree for the payment of money shall be made where the total money amount of the decree does not exceed 2,000 rupees, where the execution for the purpose of execution of the decree the order does not contain that the amount is less than 2,000, then for the removal of it is thereby declared that no order for detention of the judgment debtor in the civil prison execution for the payment of shall be made, which says that any person judgment debtor shall not be detained where the amount mentioned in the decree for the execution of decree is less than 2,000 rupees. Subsection 2. A judgment debtor released from the detention under this section shall not merely by reasons of his release be discharged from his debt, but he shall be liable to for rearrested under decree in execution of which he was detained in a civil prison. What has happened now? This says that when a person is detained and earlier and now released, this does not allow him from discharging his debts. Just because he is released for once, this does not also mean that he will not be rearrested. He will be again rearrested for the under the decree of execution, and for which he was detained in the civil prison. He will again be detained in the civil prison only. This says that when a judgment debtor, these are conditions related to whether to arrest him or not to arrest him. What has happened? A judgment debtor previously arrested, but now he was released. This will not discharge him from his liabilities. This will not discharge him from his liabilities because he is liable to do the act. He is liable to perform the execution which is in the decree, and so he will be liable to be rearrested and to detained again. Section 59, release on the grounds of illness. Section 59 subsection 1, any at any point of time after a warrant for arrest of a judgment letter has been issued, the court may cancel it on the ground of a serious illness. The court will have to cancel the warrant for the arrest of the judgment letter if he is seriously ill on the grounds of illness. Subsection 2, where the judgment debtor has been arrested, the court may release him if, in its opinion, it is not fit in a fit state of health to be retained in the civil prison. When the judgment debtor, as per the views of the court, in the opinion of the court, he is not in a state of physical fitness, so he cannot be retained in a civil prison. Subsection 3, where a judgment debtor has been committed to the civil prison, he may be released thereafter by the state government on the ground of the existence of any infectious or contagious disease. When the person detained, a judgment debtor, is having the disease which is contaminated, which can be passed on from one person to another, it's contagious, infectious, then on the ground of that disease or by committing court or any other court to which that court is subordinate, by committing the court or to any other court to which it is subordinate, to that court the executing court is subordinate on the grounds of his suffering from any serious illness. When the superior court to the executing court, when the executing court is subordinate to a court, then that court orders on the ground of his suffering any serious illness, he will be released. Subsection 4 states, a judgment letter released upon this under this subsection may be rearrested, but the period of his detention in the civil prison shall not be in aggregate exceeded that prescribed by section 58. As per section 58, the period has been mentioned as when the execution amount is to more than 5,000, it shall be he shall be the judgment letter shall be detained for a period of not exceeding 3 months, and where the decree is for the payment of a sum of not exceeding of exceeding 2,000 but less than 5,000, then he shall be detained for not exceeding 6 months. That period must not be exceeded when such person is again rearrested. When such person is again rearrested, then the total period of his detention in the civil prison shall not be more than as